Welcome to our YouTube video series on employee payroll and employment law. My name is Christopher Neufeld of Neufeld Legal. And in this particular video, we will be looking at the concept of paid vacation. Paid vacation tends to be a contractual construct designed to provide employees with employer-prescribed vacation time and continuity of employee pay on terms determined by the employer. The concept of paid vacation is prominent in the United States of America and, in our professional opinion, erroneously implemented all too often in Canada. That is because paid vacation in practice is extremely malleable and does not work well when payroll is subject to strict formulas for their calculation, as is typical with Canadian employment standards legislation. So how does paid vacation operate? It is intended that during the period during which the employee is on vacation, the employee will receive their regular pay. However, this is where the situation gets tricky, and it really only works where the employment arrangement is not subject to a very regimented employment standards legislation, and instead is largely at the discretion of the employer's employment contract. With respect to an hourly employee, paid vacation tends to be accumulated vacation time that, when taken, results in the employee receiving their base hourly pay as if they had worked a complete day's work for each accumulated and utilized paid vacation day. So by way of an example, if an hourly employee is provided 2 weeks paid vacation per their employment contract, and they typically work 40 hours a week at $30 an hour, if they took a week-long vacation, they would typically be looking at receiving pay for that week in an amount of $1,200 less permitted deductions, with this being consistent with the employment contract. For salaried employees, the process tends to be working as a continuation of the employee's salary during their prescribed paid vacation, with the idea of providing days off without adversely impacting the employee's annual salary. Once again, by way of example, this typically works in one of two ways. Approach number one sees a regular salary payment being made while the employee is on vacation, provided that the employee had available paid vacation days, with there being no separate and distinct payment of vacation pay. So for an employee with a salary of $77,000 a year, receiving a $1,500 a week and paid bi-weekly in the amount of $3,000 prior to permitted deductions, during a 2-week period in which they took 1 week of vacation, their available paid vacation would see them continue to receive $3,000 prior to permitted deductions, even though they were not working and on vacation for one of those 2 weeks. Approach number two sees their regular salary payment being subject to an appropriate reduction in that salary payment for the days not worked, which is offset by a corresponding vacation payment provided that the employee has available paid vacation. So for a similar employee with a salary of $77,000 a year, receiving $1,500 a week and paid bi-weekly in the amount of $3,000 prior to permitted deductions, during a 2-week period in which they took 1 week of vacation, their available paid vacation would see that even though $1,500 was deducted from their salary payment, this would be offset by a corresponding vacation payment of $1,500, such that the employee would net $3,000 prior to permitted deductions, even though they were not working and on vacation for one of those 2 weeks. However, the system actually works to the employer's benefit in that it aims to curtail additional vacation time. And even more consequential is that paid vacation for salaried employees in the United States of America typically does not result in an augmented payment above and beyond their salary, but merely the continuation of their salary through the paid vacation period, such that by year's end, those employees have only netted their salary as prescribed by their employment contract. This can be explained by the absence of government-imposed vacation requirements, with nothing to be found in the U.S. Fair Labor Standards Act, and only certain government employees receiving the benefit of legislative vacation, such as with the McNamara-O'Hara Service Contract Act or the Davis-Bacon and related acts. Meanwhile, state legislation, where it does address paid vacation, is largely limited to ensuring employer compliance with the employer's own policies and contracts. In Canada, due to applicable employment standards legislation in each of the provinces and at the federal level, there are statutory minimums for each of vacation days and vacation pay, which varies between jurisdictions but is not consistent with the U.S. concept of paid vacation. As such, when a Canadian employee determines that they are operating on a paid vacation system, that employee needs to seriously question their employer's payroll, as there is a substantial likelihood that it might well be contravening applicable employment standards legislation and resulting in significant employee underpayments. Thank you.